Welcome to the Contract Law Lecture Series at the University of the West Indies Faculty of Law at Cave Hill. My name is Mahncke and today's lecture is on exclusion clauses. Here's a brief overview of what we're going to be looking at. First, I'll introduce you to the general notion of exclusion clauses, and then we look at the two constituent elements of exclusion clauses. First of all, the inquiry of whether an exclusion clause has been incorporated into the agreement. And secondly, whether the exclusion clause is clear enough, the clarity of it. And lastly, I'll offer a brief summary. In a nutshell, exclusion clauses are clauses that seek to limit liability or exclude liability in contractual situations. Now, we find different terms for the same thing. So sometimes they're called exclusion clauses, sometimes they're called exemption clauses, sometimes they're called limitation clauses. Essentially, all of those are the same thing. Although, mind you that when you go on and do other subjects such as tax law, you'll find there are differences between the term exclusion and exemption. But for our purposes, we can use the term exclusion clauses to describe all of those types of clauses. Now, these clauses would usually appear in commercial agreements or in consumer agreements. So if you go and buy something in a shop, let's say you go and buy a consumer product such as a new TV, the shop may bind you to certain terms and conditions of sale, and for instance they'll limit their liability in terms of any defects of that TV and so on and so forth. And so those are exclusion clauses which would prevent you from suing the shop or returning the TV perhaps, or claiming compensation in certain circumstances, depending on, of course, what the clause says. The courts, however, even where there are these clauses, can intervene. They can lessen the effects of such clauses based on common law rules, which we'll look at. Another way that exclusion clauses can be weakened or in fact mitigated is by way of legislation. There's different types of legislation that address exclusion clauses. The Sales of Goods Acts are one example, Consumer Protection Act, things like that. So for instance, in the example related to the TV that we bought in the shop, under most Sales of Goods Acts, regardless of what the exclusion clauses say, so regardless of what the shop's terms and conditions say, a consumer is entitled to a minimum warranty period, just as an example. Leaving aside this possibility that legislation intervenes and either nullifies an exclusion clause or mitigates it in some way, leaving that aside, in order for an exclusion clause to be valid, we have to satisfy two requirements. First of all, it is of crucial importance that an exclusion clause is in fact incorporated into the agreement, incorporated into the contract. So that's the first thing we're going to look at. And then once we're satisfied that indeed an exclusion clause is part of a contract, has been incorporated, we have to look at the exclusion clause itself to make sure that it is clear as well as wide enough to be able to be relied on by the person who's seeking to enforce it. In other words, if a party, say a shop who sells you something, if they want to rely on an exclusion clause, they have to make sure that their exclusion clause is wide enough to cover the exclusion as well, and perhaps more importantly, clear enough. It has to be absolutely clear what is being excluded. So that's the second thing we're going to look at. Now, in terms of incorporation, the question of whether an exclusion clause has in fact been incorporated into the contract, whether it is a contractual term. When we look at that, there's different possibilities. The first possibility is where the document in question, the contract in question, has been signed by the parties. Now, a certain rule applies to that. Then there's also rules relating to documents, contracts that have not been signed. And there's also possibilities of incorporation by way of previous dealings. So we'll have a look at all those options. Let's start with the option where the agreement is signed. So there's a contract between, say, buyer and seller, such as in Lestrange and Graucob, and that contract, that agreement has been signed by the parties. So in Lestrange and Graucob, Miss Lestrange ran a cafe, and she wanted to have a vending machine for her cafe. I think it was a cigarette vending machine. And so she bought one from this company called Graucob. Now, what happened was that shortly after she bought it, the machine jammed and was no longer useful. It couldn't be used, and indeed it couldn't be repaired. And so Miss Lestrange wanted a refund. She wanted to return the broken machine. However, the contract which she had signed between herself and the sellers of this vending machine stated that the sellers were not liable for any such defects. The court held that this term was incorporated into the contract. That means the exclusion clause was a contractual term simply because Miss Lestrange had signed the agreement. That was enough to make sure that the term was indeed incorporated. So as a general rule, if the agreement is signed, all of its terms are incorporated, including exclusion clauses. So what happens if the agreement is not signed? Well, we've got a number of cases, situations that we can look at to try and clarify that situation. So first of all, it's not as simple as where it's signed. Where it's signed, the clause, the exclusion clause, is incorporated. Where it's not signed, the answer is basically it depends. And specifically, it depends on whether reasonable notice of the exclusion clause was given. Probably the leading case, the landmark case on this, is Parker and Southeastern Railway. What happened in this case was that Mr. Parker left his luggage with the railway company. And when he left it, he got a ticket. So he would take the ticket and return it after a while, and then they would give him back his bag. And the ticket stated on one side that there were terms and conditions, and it said something to the effect of see reverse side or turnover or something to that effect. Now, Mr. Parker was given that ticket, and he never bothered to look at the other side of the ticket. Now, if he had done so, he would have seen that the terms and conditions of the railway company were listed on the other side. And one of those conditions was that in case the bag was lost, or in case any bag was lost, the maximum liability that the railway company was willing to incur was £10, which of course, we're talking 1877, is a lot of money. Now, as it turns out, the railway company did lose Mr. Parker's bag, and as it also turns out, £10 was not enough to cover his loss because the bag and its contents were more expensive than that. So Mr. Parker sued. Now, the court basically had to decide the question of whether or not the exclusion clause, that means the maximum £10 as compensation, that clause, whether that had been incorporated. And the court held that when Mr. Parker was given the ticket, that was reasonable notice because he was expected to have looked at what he was given, and if he had done so, he would have seen that not only did the ticket have a number, which of course is the identifier for his bag, but it also mentioned that there were terms and conditions on the other side. And then if he turned it around, he would have seen what those terms and conditions were. And the railway company was not at fault for Mr. Parker not doing that. They had given reasonable notice, therefore the term had in fact been incorporated. However, we can contrast Parker to another case which is called Interphoto Picture Library and Stiletto. What happened in that case was that the Interphoto Picture Library was basically a depository of stock pictures, stock photos, things like that, which you can use for perhaps publishing. So in this case, Stiletto wanted to use it for an exhibition. So they had ordered a number of these stock photos, which had then been prepared for them, and then someone from Stiletto went to pick them up from Interphoto, and they were all in a bag. Now, inside this bag was also a little notice which contained the terms and conditions of Interphoto. One of those terms and conditions was that if the stock photos were not returned on time, there was a penalty of £5 per day, per photo, which obviously, if you've got a lot of photos and if you're late by a few days even, that can add up to quite a bit. Now, in the event, Stiletto never used those stock photos because the exhibition didn't go as planned and they never even opened the bag. Now, when they eventually figured out that they were supposed to return the bag, and I think they were about 2 weeks late, the Interphoto company said, well, you have therefore incurred a penalty of so and so much money. It was in the thousands because the £5 per photo per day added up. Now, Stiletto argued that they're not going to pay because they had never been told about this particular clause whereby they had to pay this penalty. And so again, the court had to look at the facts. Had reasonable notice been given? And the court held that having some notice inside some bag was, unlike Parker, not enough. That was not reasonable notice. The court also said that where the terms were very onerous, that means where the exclusion or the terms of a contract are more onerous than might be expected. So for instance, £5 per day per photo might be considered quite onerous. The obligation on the person who's trying to rely on those terms is a higher one. So where you have an onerous clause, you have to make a special effort to let the other party know about that. Now, this can also be seen from the case of Thornton and Shoe Lane parking. It's a very interesting case. In this case, Mr. Thornton parked his car at a car park which was owned by the Shoe Lane Parking Company. Now, the Shoe Lane Parking Company also excluded liability, for instance, for any losses, any injuries, things like that. Now, a few hours after Mr. Thornton had parked his car, he was hurt inside the car park, and so he claimed compensation. The car park company was trying to rely on the exclusion clause to exclude them from having to pay such compensation. Now, a couple of issues here. First of all, again, the court said that where the clause is onerous, the obligation to give notice rises. You have to improve, in a sense, the reasonableness of giving notice. So if the terms are not very onerous and you just hand someone a ticket, that might suffice. But where the terms are onerous, you have to make a special effort to let the other person know of those terms. So just handing over the ticket may not be enough. You may have to actually hand over the ticket and tell them to have a look at it and tell the other person about those terms. So the more onerous the clause, the better notice of it needs to be given. However, that is not the crucial point to Thornton. To Thornton, the crucial point was this, and this is a very useful rule which we can apply in many other scenarios. By the time that Mr. Thornton saw or even could have seen the exclusion clauses, or generally the terms and conditions under which the car park operated, by that time, his contract with the car park company had already been formed. And the rule that the court pronounced, and in fact this was a well-known rule already, it was just another scenario in which the court was able to apply it, was if the contract is formed and notice has not been given, you cannot then give notice retrospectively. So in other words, you have to give notice of your terms and conditions either before or at the time of contracting, not after. And this is actually very interesting from an offer and acceptance point of view, so not strictly within the sphere of exclusion clauses, but the court held that the ticket that you get from a machine at the barrier when you enter a car park, that is an offer, having the barrier and the ticket there. By pulling out the ticket, you have accepted the offer. So at that point in time, the contract has been formed. Another way that it might have been argued was that the taking the ticket was basically an offer. The ticket itself was an invitation to treat, and taking it was an offer which then still had to be accepted by the car park. But the courts rejected that argumentation. So having the ticket in the machine is an offer. Mr. Thornton taking the ticket out is acceptance. The contract is formed. And so anything that happens afterwards, that means once Mr. Thornton enters the car park and there's a big sign there saying we exclude liability and so on, anything that happens afterwards is too late. It no longer is incorporated or can be incorporated into the contract because the contract has already been formed.